Oh, right. Let me see here. Let's restart right now. And welcome, everybody. You're welcome to our program. Just a moment. Our program, ADR News. And today we are very happy because we have a very, very special guest. And this guest is very special for us, it's very special and for our talk today. And the program, the podcast ADR News is back with a very, very relevant uh, issue we're going to talk today. And this issue is very important because today we are going to talk about arbitration. And this arbitration, commercial international arbitration for me is so beautiful and so relevant for me. And I don't want to talk about more. I want to let our guest to talk about herself. But before, I'd like to introduce you. Her name is a little bit difficult for me from Brazil because it's Rahat Tabassum, and she's from Bangladesh. She's a barrister at law of Lincoln's Inn and senior associate at Arifin and Associates Dhaka. Her practice focus on civil and commercial litigation, arbitration, and mediation. She is an accredited civil and commercial mediator and an associated member of CIRB. Her professional interests include international arbitration, ADR, AI governance, digital regulation, and the financial crime. Well, good morning and welcome, Dr. Rahat Tabassum. It's a little bit difficult, but let's go. Thank you very much for being here with us. We are very happy to have you here. So, the floor is yours, please. Good morning.
Uh, Good evening from here. Thank you for the kind introduction. It's a pleasure to be here, and I'm really looking forward to our conversation.
Oh, very, very, very nice. Very good. Thank you so much. And you that now are attending our podcast, please feel free to talking to us to ask if you want to ask anything. And here we are to help people to understand a little bit more about this international commercial arbitration and basically involve the global commerce and the use responsible of the AI, the artificial intelligence. Good morning. So let's go here to the. Oh, we have a first question for you. That's very. I'm very curious about that. Rahat, doctor,
Mhm.
international arbitration has continually evolved to meet the needs of global commerce. Do you see artificial intelligence as the next major transformation in the field? Because this is our point of view, the arbitration and the AI. Please, how do you see that?
The honest answer is actually yes, but it's a with a distinction I want to draw first. Arbitration has adapted plenty of times before, and it's worth separating those changes into two kinds. There were some legal changes if we look at the New York Convention, the UN Citral Model Law. Others were technological. There were electronic disclosure, electronic bundles. Then, after the pandemic, we started to move towards the virtual hearings. The legal ones actually reshaped the framework around arbitration, how awards travel across borders, what a supervising court can and can't do. The technology ones actually changed how to process, how the process works, how documents are presented and exchanged, and whether people have to be physically present in the same room. But none of them changed who was doing the thinking. That's why I would put AI in a different category. It doesn't change how arbitration work actually, but it can change how the legal analysis itself gets done. And you can see the difference in these two examples. If I use in like to sort 10,000s of documents to build a chronology, that's an old task done faster now. But once AI starts shaping how a tribunal weighs evidence, reads authorities, or reasoning in an award, we are completely into an entirely different perspective. The reason that matters is the tribunal's personal adjudicative mandate. The parties pick the arbitrator, so they are entitled to those arbitrators' judgment, not somebody else. Which is why I would say the question isn't whether AI is coming into arbitration, because it's already are. The question is now where the line sits between the technological assistance and, of course, the adjudicative judgment.
That's right. Yes, this is a question that they have to make and have to understand. Yes, I always say that the new the new always come.
True.
The problem is how are we going to welcome the new? The new will always
Absolutely.
come. Yeah. Oh, I have another question for you here. Very interesting. Is which stages of the arbitral processes stand to benefit most from the responsible use of AI?
So, this is the part actually I'm genuinely optimistic about. So, let me start where the case is actually the strongest. The parts of arbitration that are less about discretion and more about volume. Some of the cases which we saw that it's run to enormous document sets, particularly in commercial and investment disputes. And that's exactly where AI can earn its place. It can do the review, classification, cross referencing of the evidence. But if we become more specific about where it actually helps, because cost and efficiency, I think you will agree with me, is a phrase we often use in arbitration, and it has uh, stopped meaning much now. A well resourced party can already put 12 lawyers on a document review. It may be expensive, but they can afford it. The real difference is for the party that cannot afford that kind of team at all. For example, a smaller claimant or a respondent in a jurisdiction with a very small legal market. For them, it's get quite difficult. And that matters because arbitration has been criticized for cost and delay for decades. This one is one of the few development that can actually reduce those problems rather than simply talking about them. And including this, there's one area, and it gets very less attention than it deserves, is translation and the transcription. Language, I believe, is perhaps a real practical barrier in international arbitration. So if AI translation and transcription become reliable enough, multilingual proceedings get more accessible and cheaper to run actually. Then
Yes.
there is another side I would focus, that is research. Research is another area where AI can make a real difference. But here is the accuracy issue. AI can help lawyers to find cases, identify relevant authorities. It can assist to work through large volumes of material very much faster. But that is only useful if the material it produces can be verified, because AI can produce a case or authority that looks very genuine but simply does not exist. That responsibility ultimately rests upon the arbitrator or lawyer who is using AI for the research, not on anybody else. So I would like to draw attention on a case which is Mata versus Avianca, where lawyers filed fabricated authorities that came straight off the ChatGPT. So based on all that, this is where I would draw the line. The more the task is about admin, organization, if someone is processing information, the more useful AI is. But the closer it's get into deciding the facts, or if we are assessing witnesses, applications of the law and we are deciding who should win, the more the legal and ethical problems actually starts to appear.
Yeah. I understand you, and I agree with all you have said. And I guess that nobody can
Mhm.
say no. Nobody can say no to the AI. It's a
Mhm.
real life. It's a fact. We cannot
Exactly.
deny it. I guess you have to know and have to learn how to use it with
Yeah.
ethic, with ethics, and we have to understand what's the limits that are going to use the AI. But we cannot say no. In arbitration and mediation and in the law, in the courts here in Brazil,
Mhm.
many judges they are using AI, lawyers, and so on. Everybody in the school, in the university, we have a lot of. The problem is people must use with responsibility. That's my
Definitely.
point of view. Oh,
Definitely.
but I have another question here. What are the most, in your opinion, the most significant legal and ethical challenges AI presents for international, specifically for international arbitration, particularly around confidentiality, data securities, bias, and transparency? For me, one thing that's making me feel sometimes very worried about is the problem with the confidentiality because all the process the is confidential from the beginning to the award. Please, I'd like to hear from you.
Yeah. So you have named four there, and but I would just make one adjustment because two of them are closely related, but they are actually very different problem. So if we start with confidentiality, since it's one of the main reason people choose arbitration in the first place, because parties are dealing with sensitive contracts, financial information, trade secrets. So the moment that materials goes into an external AI system, the tribunal and council they need to know what happens to it next, which is how this turns into a professional responsibility question very quickly. But if we talk about the data security, that's completely a different problem. So, confidentiality is the duty you owe to the parties, and data security is a question about complete infrastructure. The distinction matters because an arbitrator can take confidentiality seriously and still have put the whole evidentiary record into a system where he doesn't know what the system does with the information now. So there are very different questions to ask here, including some practical ones, which are when we're just putting the information into the AI, where it's stored, in which jurisdiction, who processes it, how long it will be kept, will it be used for training purpose in the future, and what happens if there is a breach. And I would say that the last one is worth pausing because these kind of failures are actually same because a confidentiality breach concerns the obligations to keep information confidential, and when you talk about the data security breach it raises the possibility that the material has been accessed, disclosed, or compromised by the people they never chose. Which is why I would say an arbitrator who can't tell what happens to a document after it's uploaded isn't in a real position to give the parties an assurance about confidentiality at all. And if we now talk about the bias, and it follows from how this system work, they learn from data. So whatever they're trained on shapes what they produce actually. So, if past arbitral decisions contain biases or some recurring patterns, a AI system trained on them can carry those forward actually. A subtle problem here is also an anchoring, which I find actually more troubling in this AI thing. If AI gives an arbitrator an early assessment of which side has a stronger case, that assessment can influence how he interprets the evidence. So that impression can color how the arbitrator now reads the evidence or even if he deciding the thing independently in the end. And the fourth is transparency. Uh, this is where I would put the problem of hallucination, because the concern is not only that AI can be wrong, but that its output can look authoritative even when it's wrong. So a hallucination is in the AI isn't an obvious error. That's precisely the problem. It can look completely authoritative and it's actually invented by the AI. And the reason that makes it a transparency problem, not just an accuracy problem, because the parties cannot challenge what they do not know is there. So, if a fabricated authority enters the tribunal's reasoning without knowing that AI has produced it, nobody might have a reason to stop and verify it. That is why I would not treat this as merely a technology problem. So, if the tribunal uses AI generated materials that is affecting its decision, but the party doesn't get to see that material or have a chance to explain or argue against it, the party may not have had a fair opportunity to present or defend its case.
I understand. Here in Brazil,
Yeah.
confidentiality is
Mhm.
the main point that attracts people to go to arbitration process. In our law, the confidentiality is the main point. However,
Mhm.
many people, many lawyers, and many other ones, professionals, arbitrators, do not understand, or they just pretend do not understand. And we have sometimes people confidentiality. Sometimes they are shown. That's a great problem. And my my main concern is AI can improve arbitration, of course,
Of course.
but it also raises serious concerns about confidentiality and data security, bias and transparency, as you told before. But the challenge is, my opinion, is to use AI with responsibility, as you who told before. Responsibility is all. Okay, and how do you see, in your opinion, Dr. Rahat? How can arbitrators embrace technology innovation while safeguarding due processes, party autonomy, and procedural fairness? It's a hard question. What do you
Yeah.
say?
I think the practical answer to use the technology, but set clear rules around it to use it from the beginning. And I would be specific about when to do, because we often say early stage on its own. But what do I mean by early stage? I mean when it starts actually. So I believe that from the first case management conference, when the tribunal is preparing procedural order number one, that order already covers things like production, confidentiality. So AI can be dealt with there as well. And if we are putting AI rules into that order, three things would do most of the work. First, what AI can and cannot be used for. Then,
Yes.
when it is used and when to be disclosed and to whom we are disclosing it. And finally, how confidential information will be protected, which system can be used, where that data goes, and how long it is kept. The reason to deal with this right at the start is simple. You address the issue before it becomes a problem. Suppose if a party waits until the award and then he relies on the AI issue to challenge the award, the issue has taken much more serious consequences. It's no longer just a procedural question, it has become a dispute whether the arbitration itself was conducted fairly. That
Yeah.
is why institutional guidance is important. It's give arbitrators like practical guidance to on how to use AI responsibly and how to address this issue before they become problem. Those guidelines aren't there just to stop the innovation. They are there to make technology is used with consistency with the procedural principle we already have. And if when we talk about these principles, I believe that people will agree that in arbitration, for the right to be heard, party autonomy, human oversights, these are important. That party should know and have a chance to respond if AI affects the tribunal reasoning. They should be able to raise this concern if AI is materially affects the process, and the arbitrator must always assess the AI's output himself. All these things actually not new. They reflect the basic principles that have always applied in arbitration. Arbitration has always distinguished assistance from delegation. For example, a tribunal secretary or a research assistant can help the tribunal, but neither can stand in for the tribunal's own judgment. I believe the same rule should apply for the AI, that it's an assistance, not we are delegating it the work to do.
Very, very interesting explanation. Thank you so much. Well, today we are interviewing the doctor Rahat Tabassum, and
Apologies,
she's
it's
talk.
not doctor actually. I'm not
I'm not
doctor, it's a
doctor. No,
bachelor.
because here in Brazil, all lawyer are called
Oh,
doctor.
oh,
In Brazil, all lawyer are called doctor. I'm sorry for it. In
oh,
Brazil, all lawyer. Well, I do not agree. Yeah, because I believe that only when you are and you study, when you
oh,
fence
that's
a
interesting.
thesis. For example, I am a PhD because I defend a thesis. I have a postdoctoral too. But here in Brazil, it's cultural. We call
Oh,
everybody doctor, everybody doctor, everybody here is doctor. I think that I believe also in Portugal. I believe that all people that finish university is called, but you are a barrister. You are a
yeah,
barrister. Am I right? So,
yeah.
so today we are listening to, we're interviewing the barrister Rahat Tabassum from Bangladesh, and she's talking about a very interesting and modern issue, the future of international arbitration in the age of artificial intelligence. And many people are afraid of listening to this is very interesting, that Rahat. People are afraid to listen to about that. No, it's not true. Because when you are afraid, we say it's not true. That's
Hmm.
but have to understand that. Another question for you.
Hmm.
If look, if AI assists in preparing or drafting parts of an award in every part of the planet today is like that. Thus, that create tension with the requirement that the tribunal itself must exercise independent judgment and provide a reason for its decision. That's a very interesting question. What is your point of view about that?
Yes, and this one I would call genuinely difficult rather than actually interesting, because the tension only bites if you separate drafting assistance from decision making. Arbitrators have always received assistance from tribunal secretaries and research assistants, as I said earlier as well. So I don't see much difficulty with AI helping with routine tasks such as formatting or identifying inconsistencies in a draft. The important point is that the arbitrator remains responsible for the judgment and the final decision. But the situation changes when AI starts influencing the substance of the decision. For example, finding of facts, assessments of credibility, drafting. That's the tribunal's mandate. They are part of the tribunal's decision, and it's making the function. And this is where the duty to give reason becomes especially important, because the tribunal must be able to explain how it reached its decision. A, re- a reasoned award isn't just an award with paragraphs of explanation attached to it. The reasons are there to show that the tribunal actually worked through the submission and the evidence, and it has arrived on its own decision. In fact, I would put it more strongly than that. The reason award is actually the only window the parties ever get. They are in the deliberation, they don't see the drafts. The document is the only proof they will ever have that their case was engaged with, and it's also what a supervising court reads if the awards get challenged. So if the reasoning was generated rather than reached, the window will show nothing. You get the appearances of reasoning without the tribunal having actually done the reasoning itself. And I would refer a case here actually again. That is ARIHQ versus Sante Quebec. The authorities on which the arbitrator relied on didn't exist. So, and it's not just some of them, they were only legal and cases authorities supporting his reasoning, but none of them were real. The court annulled the award because it found that the arbitrator had delegated part of his decision making to an AI
Yeah.
and had failed to independently verify those material it produced. There is, I mean, this one detail is worth flagging because it actually gets missed. He never admitted using AI. The court inferred that AI has been used and that decision making had been delegated on the balance of probabilities because the cited authorities couldn't be found and led nowhere. I believe the lesson people take from this case actually the wrong one. It isn't that AI is banned. It's that AI can assist, but an arbitrator can't hand over the decision, and the court made that distinction very clear. The court didn't say that every use of AI or every erroneous citation requires an award to be annulled. The real issue is whether the use of the AI compromised the integrity of the arbitration or caused the tribunal to delegate its
Yes.
decision making responsibility, which comes back to the same place that AI can help prepare the award, but the tribunal has to own the reasoning. The arbitrator has to be able to stand behind every findings, every legal proposition, and the decision itself.
Yes. Well, yes, and like I think AI can be valuable support tools
Mhm.
for all, of course, provided that the arbitrators remain fully responsible for the reasoning of final decision. I think
Definitely.
the key is to ensure that technology supports rather than replace independent judicial judgment. But I think that today the way the world is is walking, I think to be so difficult. Many things, many tribunals will be replaced. Many of the word will be
Mhm.
replaced totally, totally in the by the AI. Sometimes they are much more. Just recently, I issued a word. Then I asked it to the AI to comment about. Do you know what the AI said? Do you know
Yeah.
what it said? It was 7% made by AI. No, it was made by myself. I made by myself, and I asked them, and they said that it was made, but it was not. I just asked the AI to comment about. So sometimes today I'm afraid what the AI say is AI and what's true and what's not true. What
True.
we call the false positive. That's a
Yeah.
very important. Very interesting. Oh, they discuss it. There's a person here in our YouTube. The name is How to Resolve a Conflict 8002. Says very important and interesting discussion. Yeah, thank you very much. And CEOs, I think the key point is whether or not the tribunal delegates its reasoning, which is a
Mhm.
core part of the decision process to the AI assistant it. Perfect. Thank you very much. how to resolve a conflict. 8002. Thank you for your participation. Thank you very much. Okay. Well, let's go to the next question. Oh, this one. I think that we have already talked about, but it's very interesting. How do you think the the existing AI guidelines developed by arbitral institution provide sufficient guidance for arbitrators, or is a more uniform approach needed? What's that?
The absolute short answer would be they are a good start, but I wouldn't say they have solved the problem. And the reason is, if it comes down to distinction, I think we draw sharply enough guidance versus legal consequences. Say an
Yeah,
arbitrator breaches an institutional AI guideline. Does the award fall? Of course not. The breach has to lead to something that the law recognizes as a ground for challenging the award. For example, a denial of due process or a failure to follow the procedure the parties agreed, or a failure by the tribunal to exercise its own decision making responsibility. So, a guidance can tell an arbitrator how to use AI responsibly, but it cannot by itself determine what legal consequence a national court should attach to a breach. That is why I would be cautious about creating one global rule book. I would rather see a convergence around a set of common principles. UN Citral can be useful reference point alongside the institutions and the professional bodies. At a minimum, uh, I would want consistency on verification, the right to be heard, disclosure, and the tribunal continuing responsibility for the award. But the arbitration is flexible on purpose, and different cases needs different handling. So my preference would be to converge on the principles, not on every procedural detail.
very interesting. Yes, I agree. I think that it's the main point, and
Yeah.
also I believe that the existing guidelines are an important step forward, but the greater harmonization could provide more clarity and consistency. That's my opinion. It's not easy at all. Not easy. We are talking here about our what is our opinion, but it's not easy at all. I have another question here. Is how do you see the role of arbitrators involving as AI becomes more integrated into arbitral practice? It's a very interesting question about the practice of arbitration.
Yeah, this one actually I find most interesting actually because partly I think that we tend to look at it from the wrong direction. The obvious point is that a lot of arbitrators' time goes on processing the information, they're reading the submissions, organizing evidences, checking authorities, and trying to getting on top of a very factual record. And AI can take some of that off. But there is another issue we don't talk about enough, that parties can also use AI to analyze the arbitrators, their past decisions, reasoning, and potential biases. There are analytics products now sorry, that will tell you how a particular arbitrator decides, how fast or
Yes.
how often for claimants, how he has handled a particular kind of objection, and that changes the appointment process quite a lot. And this raises a question I genuinely don't think we have answered. If a party chooses an arbitrator based on an AI generated profile of how that arbitrator has decided cases in the past, is that simply an exercise of party autonomy? Or is it because something closer to forum shopping, choosing the decision maker because the party expects a particular outcome? So I don't have a settled view of that yet, but I suspect this becomes a real concern sooner than the drafting issues which we have been discussing earlier. And there is a legitimacy point underneath all of this. Parties don't just want an efficient answer, they want to know that the tribunal they chose actually considered their evidence and arguments and then made the decision itself. So the
Yes.
tribunal's role is not just to make the decision, it must also verify the information being used and remain responsible for the integrity of the process. Arbitrators do not need to understand some basic thing uh, about AI system handle information, but they do not need to be technology experts. Just the basic understanding is enough for them. For me, that comes down to two basic things. First, an arbitrator should understand what happens to a document once it's uploaded, which AI system receives it, and how long it's kept. And second, an arbitrator should understand that AI can sound completely convincing even when it's wrong. A fabricated authority can look exactly like a genuine one. And the useful thing about both is that they are testable. An arbiter can answer them or he can't, which leads somewhere slightly counterintuitive point. The good arbitrator 10 years from now won't be the one using the most AI. It will be the one who knows when AI helps, when it's dangerous, and when he has to take over and use his human judgment.
Yeah. 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 I believe also that the arbitrator do not need to know how to understand really technology, but needs to know
Definitely.
the basic. I always say you have to know the basic because uh, I see arbitrators becoming even more focused on judgment,
Mhm.
strategy, ethics, and human understanding. The most important is human understanding. People sometimes I see the arbitrators they want to transform some arbitrators. They want to transform uh, the the arbitration into a court litigation, and
Yeah,
it's a point of different people here in Brazil when they look for the arbitration, they look for something because the arbitrator is hired by that parts. That they need to understand that, and they look for fast procedures, ethics, confidentiality, and so on. And AI, of course, can assist with efficiency, but my dear Rahat, the arbitrator experience
yeah,
and the responsibility remain essential. That's my point of view. So we have
yes,
here
of course.
a last question. The human touch is essential in everything of life. The human touch. The machine will never substitute it. And we have a final question for you. Could the use of AI in arbitral decision making affect the recognition and enforcement of an award under the New York Convention? This question is very hard to, but I know that you are going to answer for us perfectly.
Thank you. So the answer is potentially yes. Though AI use alone should not make an award unenforceable, what matters is how it was used and whether that use compromised the integrity of the process. So, if we talk about there are three routes under Article 5 of the Convention. So, first, Article 5(1)(b) precisely, a party unable to present its case if a tribunal relies on AI generated material, suppose never disclosed to the parties, they had no opportunity to address it. That potentially a due process problem, though the challenging party would need to show it was actually deprived of the chance to address something material. Then we have to focus on Article 5(1)(d), whether the arbitral procedure followed the parties' agreement or the law of the seat. If an arbitrator effectively delegates part of the adjudicative function to AI, the agreed procedure arguably wasn't followed. That is essentially with the Quebec Superior Court found in ARI HQ versus Santé Quebec case this April. The arbitrator had abdicated his duty of independent verification and improperly he delegated part of his adjudicative authority, and because of that the award was annulled. And third, Article 5(1) E. An award is not yet binding or set aside or suspended at the seat or under the law of which it was made. So, annulment for improper AI use could feed through to enforcement elsewhere, though not automatically, since Article 5 is permissive throughout. So finally, there is this public policy under Article 5 2b is the narrower route, and the ARI HQ itself rejected the substantive public policy argument. But procedural public policy is based on that fundamental principle of natural justice. It remains relevant. And
Yes.
unlike what we discussed earlier, the Article 5(1) grounds, which the resisting party must prove, and the 5(2) grounds can be considered by the courts on its own motion. So, where does that leave the convention? The harder problem sits underneath all of this basically. How would a party ever know? So, deliberations are private, drafts are undisclosed, and there is no discovery into how an award was written. ARI HQ came to light because the fabricated citation could be checked, though the court also held that expert evidence isn't required and that it's like internally inconsistent reasoning may speak for themselves. Still, had AI shaped how the arbitrator weighed a witness or two competing expert reports, there might be nothing in the award to show it, which
Yeah.
is why I keep returning to disclosure at the procedural stage. It isn't a complete answer, but it's the one point where parties can ask whether AI is being used and raise concerns before the award is rendered rather than trying to prove it afterwards.
Yes. Perfect. Thank you. Thank you very much. Thank you. Thank you very much for answer. And thank you. Thank you for joining us on ADR News. And it was a pleasure, a little pleasure having you here with us, Rahat, hard, Rahat, with us, and discussing such an very important and timely topic for the future of international arbitration. International arbitration as a whole, commercial, and so on. Your insights, I believe, for me and for many people that will watch this video afterward and not now, have certainly contributed to this important conversation. Thank you very much, and I hope to see you again in another conversation. We are going to discuss about a topic that we are talking before starting here. That why
Ab-
do people prefer to resolve a problem instead of prevent problems, prevent conflict? People professionals prefer to talk about conflict resolution, but they not talk about prevent conflicts. Thank you very much. It was a pleasure
Thank
seeing
you for
you.
having me
Hope
here,
to see
actually.
you. I hope to see you again and again. Have a good
Yes.
day. Thank you.
Have a
Bye
good
bye.
day. Thank you.